we see that all men mean by the term justice a moral state such that in consequence of it men have the capacity of doing what is just, and actually do it, and wish it. Similarly also with respect to injustice, a moral state such that in consequence of it, men do unjustly and wish what is unjust. Let us also be content then with these as a groundwork sketched out. Let it be ascertained then in how many senses the term unjust man is used. Well, he who violates the law, and he who is a grasping man, and the unequal man, are all thought to be unjust, and so manifestly the just man will be the man who acts according to law, and the equal man the just then will be the lawful and the equal, and the unjust the unlawful and the unequal. We said that the violator of law is unjust, and the keeper of the law just. Further, it is plain that all lawful things are in the manner just, because by lawful we understand what have been defined by the legislative power, and each of these we say is just. But the just which arises in transactions between men is an equal in a certain sense, and the unjust an unequal, only not in the way of that proportion but of arithmetical, because it makes no difference whether a robbery, for instance, is committed by a good man on a bad or by a bad man on a good, nor whether a good or a bad man has committed adultery. The law looks only to the difference created by the injury and treats them as previously equal, where the one does and the other suffers injury, or the one has done and the other suffered harm. And so this unjust, being unequal, the judge endeavors to reduce to equality again, because really when the one party has been wounded and the other has struck him, or the one kills and the other dies, the suffering and the doing are divided into unequal shares. Well, the judge tries to restore equality by penalty, thereby taking from the gain. What causes the difficulty is this: the equitable is just, but not the just which is in accordance with written law, being in fact a correction of that kind of just. And the account of this is, that every law is necessarily universal, while there are some things which it is not possible to speak of rightly in any universal or general statement. Where then there is a necessity for general statement, while a general statement cannot apply rightly to all cases, the law takes the generality of cases, being fully aware of the error thus involved, and rightly to notwithstanding, because the fault is not in the law, or in the framer of the law, but is inherent in the nature of the thing, because the matter of all action is necessarily such. When then the law has spoken in general terms, and there arises a case of exception to the general rule, it is proper, in so far as the lawgiver omits the case and by reason of his universality of statement is wrong, to set right the omission by ruling it, as the lawgiver himself would rule were he there present, and would have provided by law had he foreseen the case would arise. And so the equitable is just, but better than one form of just. I do not mean the abstract just, but the error which arises out of the universality of statement, and this is the nature of the equitable, the correction of law, where law is defective by reason of its universality. This is the reason why not all things are according to law, because there are things about which it is simply impossible to lay down a law, and so we want special enactments for particular cases. For to speak generally, the rule of the undefined must be itself undefined also,